Thank you for joining today's Technology Transactions webinar. Our program today will focus on managing intellectual property in joint ventures and collaboration agreements. My name is Michelle Ontiveros and I'm delighted to introduce today's program. I'm a partner in the Mayer Brown's Technology Transactions and Cybersecurity and Data Privacy Practices in Northern California. To give a quick overview about our Technology Transactions Practice Group at Mayer Brown, we have 50 lawyers worldwide who've done over $200 billion of data, digital, outsourcing, and software transactions. Our intellectual property practice comprises more than 100 IP professionals around the world, protecting, preserving, and enforcing the intellectual property rights and assets of the world's most innovative and inventive companies. I will cover a few administrative matters and then we'll get started. First, at the bottom of your screen, you will notice there are multiple application widgets you can use. All the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. Today's program is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presenters. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or browser sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off your VPN is recommended. If your slides are behind, pushing F5 on your keyboard will refresh the page. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. During today's presentation, you'll be provided with an alphanumeric code. If you are applying for CLE credit, you will need to record this code on the virtual sign-in sheet that you received by email with the connection details. You can also find a copy of the virtual sign-in sheet in the resource list widget entitled CLE Affirmation Form. Directions for returning the CLE Affirmation Form are on that sheet. We will read the code in the middle of the presentation and then again at the end. Please note we also made the event evaluation form and presentation deck available in the resource list widget for your convenience. This webinar is being recorded as we normally do with these programs. In a day or so, we'll be sending you an email with a link which you can use to listen to the webinar again or share with your colleagues. The recording will also be posted on our website. We do plan to allow time at the end of the program for questions. To submit a question electronically, please use the Q&A widget. If we don't get to your question during this webinar, we'll make every attempt to follow up with you afterwards. So with that, I'm pleased to introduce my colleagues joining me on today's webinar, Joy Lee. Joy is an intellectual property associate in Mayer Brown's Northern California office. Joy advises clients on IP enforcement and IP transactional matters. She leverages her decade-long IP litigation experience and background in electrical engineering to provide strategic counseling to clients in connection with complex issues related to intellectual property, information technology, and data protection. She advises clients on issues arising in a variety of corporate transactions, including mergers and acquisitions and divestitures of IP and technology assets, joint development arrangements, technology services agreements, and supply arrangements. Joy is a registered U.S. patent attorney. With that brief introduction, let's get started with today's program. And I'll turn to Joy to walk us through the agenda and get us started.
Thanks, Michelle. First, we will discuss considerations in contributing IP to a JV. For those of you who are new to the topic of JV, we'll go over the basics of what's a JV, a typical life cycle of a JV, and why one would want to enter into a JV. Next, we'll look at how effectively manage and protect jointly developed IP in the context of a joint venture arrangement. Joint ownership of IP is tricky and full of pitfalls, so we will cover that topic in detail today. Finally, we will discuss interesting cases involving business relationships that went wrong and lessons we can glean from the cases. So with that, let's get started. Contributing IP to a joint venture. What is a joint venture or a collaboration? A joint venture refers to when parties pool their resources and collaborate on a business activity, most often for production or supply of products and services or for research. A JV can be based on one of two models or a hybrid of the two. First, an entity-based JV or a corporate JV and a contractual JV. In a corporate JV arrangement, one or more parties establish a separate legal entity, such as an LLC, a corporation, or a partnership. The entity is jointly owned by the parties in agreed proportions. As an example, parties can decide to form a JV entity for the sole purpose of creating an IP holding company or a shell company. Having a separate entity like that makes it easy to enforce the entity's IP against third parties and to license the IP to third parties. A common use of JVs is to partner up with a local business to enter a foreign market. For example, a company that wants to expand its distribution network to new countries can form a JV with a local company and take advantage of an already existing distribution network. Some countries have restrictions on foreign companies entering their market, so forming a JV with a local company may be the only way into the country. A contractual JV is similar to a corporate JV in that the parties share resources such as expertise, goodwill, and capital to increase the performance of both parties. But a contractual JV does not involve setting up a separate legal entity. A contractual JV can nevertheless involve complex IP issues. The instrument that governs a contractual JV arrangement can take various forms and titles. It may be called a joint development agreement or collaboration agreement. Today in this webinar, when we refer to a JV, we mean both a JV entity and a contractual JV. A JV can be for a specific project or for a specific time period. Typically, a JV is formed for the purpose of production or research and is temporary, but it can also be for a relational or ongoing purpose. According to Bob Gray, a Mayer Brown corporate partner, JVs tend to last less than 5 years on average. Oftentimes, a JV transitions into an acquisition by one of the parties, as is illustrated by this graph, or a JV may be acquired by a competitor. Other possible exit strategies for a JV include dissolution and bankruptcy. Now that we understand what a JV is, I'll hand it back to Michelle to discuss whether a JV would be a good idea for your business.
Great. So before you jump into the formation of a JV entity or even commence term sheet discussions in the case of a contractual JV or collaboration, you'll want to ask a critical threshold question: is the JV model the right business solution? So generally, parties enter into a collaboration to create greater commercial value that either of the two parties could generate independently. And commercial value is created when two parties leverage each other's knowledge, resources, and capabilities in a common engagement. And a JV almost always includes a common or overlapping vision of some sort. We see successful JVs formed in at least 3 common scenarios. One scenario is where the parties are seeking market expansion, whether it be geographic expansion, introduction of a new product, or new distribution channels. A survey by PwC and CFO Research Services found that this is the most common reason for pursuing a joint venture. We also see JVs formed where there is a need to improve investment affordability. And by this I mean where two parties pool funds to create value that each party could not independently afford. A common example is technology development costs. And our last common scenario is where parties share risk to allow each party to have a more diversified pool of investment. For example, in the pharmaceutical space, you might have 2 pharmaceutical companies investing in new molecules. A JV tends to be temporary. As Joy noted in her previous slide, JVs tend to last less than 5 years on average, and by definition, you will not be committing to a permanent collaboration. However, as many of you know, a JV that's riddled with problems can seem to last a lifetime, and exiting the JV can be rather thorny. So it is critical that the parties tackle the tough issues up front when the collaboration has positive momentum and the parties are generally excited about the project. Once you determine that you do want to proceed with a joint venture or collaboration, you'll want to consider each party's IP rights as early in the process as possible. So I'll hand it over to Joy to walk us through some of the basics.
In order to operate a JV, whether under the entity-based model or the contractual model, the parties often need to contribute or disclose their IP related to their business. Multiple parties may contribute IP to the JV, or alternately, one party may be the sole contributor of IP while others contribute operating capital or managerial know-how. We see more and more companies entering into JVs with competitors to force new markets or to innovate. While sharing IP may lead to future benefits, you want to manage the risk of inadvertently oversharing your IP and have a clear understanding of what constitutes background IP and foreground IP. Background IP refers to IP that is made available to the collaborating parties during the term of the project. It includes IP created before the collaboration or before the effective date of the joint development agreement. It can also include IP created during the collaboration, but separately and independently of the collaboration. In other words, IP developed outside of the scope of the joint development agreement. Background IP can also include IP created after the date of the engagement and made available to the collaborating parties for the purpose of undertaking the project. Background IP is almost always owned by the party contributing it. Generally, there is no dispute that each party owns its existing IP and its independently developed IP during the term of the project. Typically, each party maintains ownership of its own IP and permits the other parties to use it according to the term of the agreement. Foreground IP refers to IP created by a party in connection with the project. So in short, background IP refers to pre-existing IP or IP created outside of the JV, and foreground IP refers to IP created from the operation of the JV. Foreground IP that's developed by one party is generally owned by that party. But legal issues rise when foreground IP is developed jointly by the parties. The U.S. patent law makes it easy to record jointly developed IP in the inventor's field of a patent. Inventors can apply for a patent jointly, even if they did not physically work together or at the same time, or made unequal amount of contributions to the subject matter of the patent. A contributor to even one claim of a patent is considered a joint owner for the entire patent and can lawfully license that entire patent to third parties. We'll devote a bulk of our presentation discussing ways to protect your rights in jointly developed foreground IP. As some of you already know, sharing is not always caring when it comes to sharing your IP in the context of a JV. So I'll hand it over to Michelle to discuss things to watch out for before you share your crown jewel technologies with your JV partner.
Okay, so let's turn to some of the considerations to keep in mind before contributing IP to a joint venture. A key issue to explore at the outset is whether the venture partners will be involved in a similar or related business. If there is a possibility that they may be, then you'll want to give special consideration to what restrictive covenants might be appropriate and what safeguards and controls might need to be put in place to ensure proper confidentiality. Once the parties understand each other's businesses and their respective future plans, the venture partners should have detailed discussions around how the existing IP assets will be used. You'll want to clearly state in the agreement between the parties that background IP will remain the property of the contributing party to the exclusion of all others, including the JV and any other venture partners. The JV may get a limited license to specified IP for a specific purpose, But ownership of background IP, as Joy mentioned, typically remains with the party bringing such IP to the project. In a situation where background IP is actually contributed, and by that I mean assigned to the JV entity, it is essential that the parties reach written agreement regarding what happens to such IP upon termination or dissolution of the joint venture. Once the to-be contributed IP is identified, it's time to do your diligence and value the IP. You'll want to confirm ownership, check for liens and encumbrances, consider whether a freedom to operate analysis is appropriate. It's important not to rely solely on reps and warranties, which often do not cover any patent weaknesses. IP sufficiency reps, for example, are only so helpful where the business has not yet been fully established. Assuming no diligence issues are identified, the parties should then agree on the value of any contributed assets. It's also important to clearly define the purpose of the project and require that the JDA steering committee revisit that definition and IP ownership terms on a periodic basis. These projects often evolve into entirely different unforeseeable projects, and the contract may need to be updated. And lastly, before disclosing any trade secrets, be sure your trade secrets will continue to be protected throughout the life of the JV, and the parties should agree in writing as to what post-termination confidentiality terms will apply. Remember, JVs often operate like startups, incorporating similar uncertainties and risks, so having ironclad confidentiality and IP rights provisions is very important. Let's move on to Section 2, Protecting Jointly Developed IP. It is very common for some form of jointly developed IP to arise out of the JV. When that happens, the venture partners have a few options to consider. The JV may own all joint IP during the life of the JV. This is great during the life of the JV, but still leaves the question regarding what happens to such IP upon termination or dissolution of the JV. You can also have one party own all joint IP and license it to the other parties or to the JV. If the venture partners take that approach, there should be consideration given to what rights each party should have during the life of the JV versus thereafter. Another question to ask is, should the venture partners have any rights to such IP, or should the license be limited to the JV itself? The venture partners can also choose to divide the joint IP portfolio among the parties. This division might be based on the vested interest of each party. It could be tied to fields of use or territories, and it could involve cross-licenses between the venture partners or the JV entity. When an IP portfolio is divided, you'll want to be sure that the parties are subject to restrictive covenants to prevent, for example, disclosure to competitors. Now, you'll note that I have not yet mentioned that the venture partners can also jointly own any jointly developed IP. As I'm sure many of you have heard, joint ownership of IP can be tricky. For example, unless the parties otherwise agree, a joint owner may license a jointly owned patent without the consent of the other joint owners and without accounting to the other joint owners. This may not be desirable to one or more of the venture partners and could significantly inhibit a party's ability to fully use its IP. Joint ownership also raises challenging issues when it comes to prosecuting, registering, maintaining, and enforcing jointly owned IP. For example, what happens if one party wants to prosecute a patent in a jurisdiction where the other joint owner does not want to, and perhaps prefers to maintain the IP as a trade secret? Similarly, if a joint owner wants to sue a third party for infringement, and let's say that third party happens to be the other joint owner's best customer, there's likely going to be a disagreement about the path forward, and the rules of the jurisdiction where the action is to be brought may require all joint owners to join as parties to the infringement. We'll get into some of these issues in a bit, but as a general matter, we try to avoid joint ownership whenever possible. Once the parties have their basic IP ownership framework in place, what will be retained by each venture partner and what rights each party will have with respect to newly developed IP, the parties should move toward documenting the transfer of the IP. Now I'll hand the slides over to Joy to walk us through the options.
There are two main vehicles for allocating IP. First, via an assignment, and second, via license. An assignment is a sale and transfer of the IP. In an assignment, the same rights vest in the new owner to the exclusion of all others, and the former owner gives up all their rights, obligations, and claims to the IP. A license, on the other hand, is short of a sale. A license is a permission for a party to use the IP, but not own it. A license allows the use and commercialization of the IP for a limited purpose or for a limited time period. Because the owner still owns the IP, the owner can still issue enforcement proceedings against the licensees who breached the terms of the license. Whether to license or assign joint IP to the other parties depends on the circumstances of each JV or collaboration. As an example, if a pharmaceutical company sponsors research by a university, the sponsor likely wants the university to assign all of its rights to the joint IP to the sponsor. If the sponsor made a substantial investment in the development of the technology, or if the sponsor is likely to be the only practical user of the resulting invention, or if the sponsor provided proprietary information, technology, or material which is the basis of the research. The next bullet point, an instrument for allocating IP may be an IP assignment agreement or an IP license agreement. But you can also have the IP assignment or license provisions in the joint venture or other collaboration agreement. Michelle will next talk about the key IP considerations in a JV agreement.
So there are plenty of IP considerations to keep in mind when drafting a JV agreement. And you'll want to think about things like the scope of the rights to be licensed. Should it be limited to a field of use for the JV? The venture partners will need to agree on the territory or market for use of any licensed IP. The joint development agreement will, of course, address which party will be responsible for developing new IP rights. One party may have a better infrastructure to support development activities. In fact, that's usually the case, which is often the reason the parties are coming together in the first place. The parties should also discuss whether either venture partners should have any right to exploit the newly developed IP outside of the scope of the joint venture. You'll want to discuss who pays for registrations and maintenance fees. And another topic that's very common is sublicensing. What happens? What kind of sublicensing rights should exist? What restrictions and requirements should apply? When the JDA involves the development of a product, the parties usually need to address rights of any distributors or manufacturers. With sublicensing rights, you'll want to carefully consider the effect of termination on the sublicenses, particularly where a venture partner has gone to market with a product developed under the JV, or where a venture partner has an existing inventory of products at the time of termination. You want the agreement to clearly spell out what rights should exist during that post-termination period and for how long. What controls are maintained by the licensor is also another topic to address. With trademarks, a licensor clearly wants to protect the goodwill associated with the marks. If the parties are going to market with a new mark to be used by the JV entity, the parties should conduct a trademark clearance and agree on how the marks will be managed and how rights in the marks and any related goodwill will be handled during the life of the JV and thereafter. And lastly, who's required to defend against third-party claims of infringement? The joint development agreement should clearly outline the process for handling IP infringement claims and each party's indemnity obligations.
I'll address some ways to avoid pitfalls in a JV agreement. First, clearly define the ownership of contributed IP and joint IP, including post-termination rights. As Michelle mentioned earlier, at the very beginning of the JV endeavor is when you want to clarify how a partner's exit or the termination of the JV will be organized and how IP assets will be shared. For example, the JV might be acquired by a competitor of yours. In that case, you'd want a provision in the agreement that automatically terminates all inbound licenses of your IP to the JV upon a change of control of the JV to a competitor of yours. You can explicitly identify the competitors or not. Second, clarify that the use of joint IP includes the right to use contributed IP of each party solely as embedded in or necessary to use the joint IP. Third, allocate joint IP among different and non-overlapping fields of use or geographies if appropriate, so that the parties will not compete with one another using the same joint IP. Fourth, specify whether parties are obligated to account to each other for profits from use of joint IP. For example, if the parties are allowed to sublicense the joint IP to third parties for a royalty, the parties should decide at the outset whether the parties must share the royalties among them. And last but not least, allocate to the contributing party the IP it created in the course of the collaboration that's ancillary to or separate from the central purpose of the JV and is derivative of its contributed IP. This is otherwise called derivative IP. Derivative IP is typically beyond the scope of the JDA. It's difficult to define and address by agreement. It's often difficult to accurately separate what's a joint development effort central to the purpose of the JV and what's a modification or derivative of a party's contributed IP. Other related questions to ask and answer at the outset of a JV is whether the contributing party has to license its derivative IP to the other parties.
So let's move back now to the concept of joint ownership. It's a common and complex concept. Joint ownership can become complex when foreign parties are involved because different countries have different default laws for rights to exploit and enforce IP, and the default laws vary by the type of IP. So whenever a foreign party is involved, a meeting of the minds is particularly important as to what the party's expectations are with respect to joint ownership of IP rights involved. As I mentioned earlier, joint ownership can create issues with enforcement and commercial exploitation of joint IP, both during the engagement or upon termination. And this is particularly true where differing businesses' needs create different patent coverage needs. Drafting, filing, and prosecuting a patent can become complicated and expensive, and the end result may not be optimal for some or all parties involved. It can also be difficult to determine accurate financial valuation of joint IP for balance sheet purposes. When a JV involves jointly owned IP, termination of the JV can be tricky. You'll want to consider what rights, if any, each party should have post-termination in the event a party needs access to the other party's IP in order to use the jointly owned IP. The issue of joint ownership becomes even more complicated when the same jointly owned IP asset is protected in multiple jurisdictions. For example, a U.S. patent and a Chinese patent if they've been issued for the same invention. If a jointly owned patent is involved in a patent litigation, most countries require all joint owners to join as plaintiffs or consent to the suit, but that is not always the case. Because different countries often have different default rules governing joint ownership, the joint owners may not be fully aware of the implications of joint ownership in a particular jurisdiction. We'll note for you that the top patent filing jurisdictions are China, Japan, Korea, the United States, France, Germany, and the UK. These are top global destinations or sources for collaboration and R&D activity. Because IP law is territorial, meaning countries enact their own laws, and these IP laws have no application or force outside the applicable country. Therefore, management of jointly owned IP can be made a bit more clear where the ownership rights of each party are allocated among different fields of use or territories. So if that's an option, I definitely recommend taking that option. Without agreements between the parties, courts look to default laws to determine what constitutes joint IP and each party's rights related to that IP. If you're involved in a joint venture that could include patent filings in multiple jurisdictions, we highly recommend consulting with an IP attorney to ensure your JDA contains express rules and processes for managing that IP. Otherwise, the default rules will apply, and they may or may not work for your particular situation. And with that, I'll turn it over to Joy shortly to walk us through the default rules in the United States.
In the U.S., for patent rights, the default rule is that each joint owner may exploit without the consent of the other joint owners and without any duty to share royalties. This is codified in Title 35 U.S.C. Section 262. Exploiting a patent includes licensing the patents to third parties. So under this default rule, a savvy prospective patent licensee can encourage the joint owners to engage in a royalty price war and ultimately drive down the value of the jointly owned patent. The default rule for enforcing a jointly owned patent is also fraught with pitfalls for the unmarried. In the U.S., a joint owner must join all other joint owners in enforcement actions against a third party, as Michelle alluded to earlier. This requirement may work as an advantage to the accused infringer and a disadvantage to a joint patent owner who's trying to enforce the patent. If any of the joint owners refuses to join in the action as a plaintiff, the patent cannot be enforced. This requirement protects the accused infringers from defending against multiple lawsuits on the same patent, and it also protects an absent joint owner from finding of invalidity or unenforceability negatively affecting his patent rights. But this also means that the absent joint owner can prevent the other joint owner from suing by either simply refusing to join the suit or by granting a license to the third party, either before the lawsuit or after the lawsuit. As you can see, the U.S. patent law on joint ownership is set up such that each joint owner is at the mercy of another. With respect to U.S. copyright law, in the middle column, the default rules are the opposite of those of the U.S. patent law. Each joint owner may exploit the jointly owned copyright without the consent of the other joint copyright owners, but they have a duty to share royalties with the other joint owners. Each joint owner may enforce without the other joint owner's consent. In the third column, trade secret laws in the U.S. vary by state, but generally each joint owner may exploit the trade secret without other joint owners' consent and without sharing royalties with them. Each joint owner may enforce the trade secret without other joint owners' consent.
Okay, now we'll move on to default joint ownership in China. The default rules in China are a bit different from the default rules in the United States. The PRC patent law was amended for the third time in 2008, and the amendment specifically addressed joint ownership of patents. So as of the 2009 effective date of the amendment, a joint owner in China is entitled to exploit the jointly owned patent alone or grant a non-exclusive license to a third party to exploit such patent. But any fees generated from such license must be shared among all the joint owners. This royalty sharing requirement is different from the U.S. approach. All other types of exploitation of a jointly owned patent must be agreed upon by all joint owners. Therefore, assigning or granting an exclusive license to a jointly owned patent must be agreed upon by all joint owners of the said patent. Also, unlike the U.S. default rules, in China, courts generally allow each joint owner to enforce without the consent of others. The default copyright rules pertaining to joint ownership are not very different from the U.S. rules. Like the U.S., royalties must be shared. With respect to enforcement, Chinese copyright law specifies that each joint owner may enforce without the consent of others, but any compensation should be distributed between the joint owners.
The third country we'll look at is the UK, and I'd like to point out here that the local default rules for joint ownership are different even inside the EU. The UK default rules for patents are the same as those for the US, with one exception. Each joint owner may exploit the patent itself without the consent of the other joint owners and without sharing royalty revenues. But consent is required to indirectly exploit the patent, including to amend, revoke, license, assign, or mortgage the patent. And each joint owner must join all joint owners in enforcement actions. For exploiting copyright, the UK default law is the opposite of the US default law, but for enforcing copyright, the UK default rule is the same as the US default law. So in the UK, no joint owner may exploit without the consent of all joint owners, and each joint owner may enforce without the consent of the other joint owners. In the third column there, in the UK, there's no trade secret legislation. So a breach of contract action where an NDA is in place or common law breach of confidence action is available. There's case law in the UK that holds that if there's no contract, then a joint owner of confidential information can't prevent the other joint owner from using or exploiting the confidential information. So it should go without saying that when it comes to a trade secret, having at least an NDA is imperative. There are other considerations when it comes to default law of joint ownership. What default law governs if the JV agreement is missing terms related to joint ownership? Is it the choice of law clause in the miscellaneous section of your agreement? And where the joint IP was created? Or is it where the joint IP was applied for or registered? If the joint owners filed for patent applications in multiple countries for a single joint IP asset, what law governs the IP asset then? The answers are not always clear and can be expensive to figure out after the fact. So consider these issues at the outset where applicable and incorporate your answers or resolutions into the JV agreement instead of relying on default rules.
Okay, now we'll move on to our case law review, always a crowd favorite. This is where we get to demonstrate the recent case law that our warnings and guidance on protecting IP and JVs is not just lawyers being lawyers. These are actual cases involving IP issues arising between venture partners. So we'll get started with our first case. The first case is the Deco-Mertec case. The joint venture entity in this case was an LLC, Ascentive LLC, which was formed in 2016 as a joint venture by the plaintiff Deco and the defendant Mertec. And the LLC was created to commercialize products based on a gas known as 1-MCP, which is used to delay the ripening of fruit and other produce. Mertec represented that it owned the patented rights in certain inventions using 1-MCP and granted the LLC, granted the joint venture, a license to use the patented rights. However, as was discovered later, 6 years before the JV entity was formed, Mertec and a company called AgroFresh had entered into an agreement calling for joint ownership of any and all inventions conceived or reduced to practice jointly by the parties. A year later, Mertec ceded sole ownership of all such rights to AgroFresh, including a series of inventions known as the Write-Lock patents. Mertec informed Deco that it had partnered with AgroFresh to produce Write-Lock, but shockingly, Deco did not ask to see any of Mertec's agreements with AgroFresh. So they are aware of this relationship, but didn't actually do any diligence on the agreement. Soon after Ascentive went to market with its first 1-MCP product, not surprisingly, it, along with Mertec and Deco, were greeted with an infringement suit by AgroFresh as owner of the patented Write-Lock technology that Ascentive used for its own product called Trupic. Parties go to court. In 2017, the court ruled in favor of AgroFresh, after which Ascentive agreed to stop all commercial activity related to Trupic. In a subsequent consent judgment, Mertec agreed to entry of judgment against it on 20 different counts of wrongdoing, including willful infringement, fraud, and misappropriation of trade secrets. Deco filed suit to dissolve Ascentive after Mertec spurned its proposal to dissolve voluntarily based on the company's loss of its sole technology. So this case is very much about the importance of due diligence. Of course, hindsight is 2020. But there's no doubt now that the agreements between Mertec and AgroFresh should have been reviewed carefully and the relevant patents thoroughly reviewed for IP ownership issues.
The second case we're going to look at is a pharma case. It's a breach of contract and patent infringement case between Eli Lilly, which is a large pharmaceutical company, and a much smaller research company called Emisphere. Emisphere is a drug delivery company. It makes what's called carrier compounds that, when ingested orally, carry the drugs to your bloodstream without having the drug being broken down by your digestive system and becoming ineffective. This is a highly valuable technology, as the judge states in the opinion, because oral medications are often more effective and cheaper to administer than injectable drugs. So Eli Lilly and Emisphere collaborated for about 5 years to create an orally ingestible drug to treat osteoporosis. The drug's called Forteo. You can look it up online. It's for mainly older women with bones prone to fractures. So these two parties used two agreements, a research collaboration agreement and a license agreement. This case actually involves well-written agreements. The judge even writes a paragraph in the opinion about how the sophisticated counsels for both parties wrote highly complex and multi-layered definitions and provisions. During the term of the project, Eli decided that it no longer needed Emisphere and established a secret research team to replicate Eli's carrier technology. Eli used even the same employees to collaborate with Emisphere and to work on the secret research team. Eli knew that it needed a license from Emisphere before Eli could commercialize the product resulting from its secret research team. Unfortunately, Emisphere did not know about this secret research team until only when Emisphere saw a patent publication from Eli that claimed the same carrier compound that Emisphere disclosed to Eli within the scope of the collaboration project. The agreements had 3 provisions that Emisphere alleged that Eli breached. One was that Eli was prohibited from using Emisphere technology for anything other than the collaboration. Emisphere technology here was defined to encompass all Emisphere carrier compounds. And the second provision was a confidentiality provision stating that employees working on the collaboration cannot disclose any confidential information to anyone outside the collaboration. The third provision required Eli to assign to Emisphere patent rights to any Eli invention or improvement pertaining to carrier compounds. The court's holding here is that Eli breached all 3 provisions, including the provisions restricting Eli's use of Emisphere technology and the confidentiality provision. The court also held that Eli's breach justified Emisphere to terminate both the research collaboration contract and the license contract, which resulted in a major loss of Eli's investment and which allowed Emisphere to enter into essentially the same collaboration arrangement with Novartis, another large pharmaceutical company. So this positive outcome for Emisphere here was possible because Emisphere's lawyers drafted robust definitions and provisions. So our practice tip here is to draft clear definition of each party's rights and include ironclad confidentiality provisions and patent assignment provisions. In addition, we advise you to monitor your collaborating partner's patent prosecution activities real time to check that the collaborative efforts are not being patented solely by your partner without your permission.
Okay, we have a few more cases for you. So the Polyzen Radiadyne case is next. This case involves a development and commercialization agreement to jointly develop a non-latex balloon catheter. Radiadyne, a successful Houston-based innovator and marketer of medical balloon devices, was sued by its former business partner, North Carolina-based Polyzen, a manufacturer of medical balloons. So Polyzen brought claims that Radiadyne infringed a patent Polyzen had procured, misappropriated trade secrets, and failed to purchase hundreds of thousands of dollars in balloons and raw materials. The collaboration concept was born when the president of Polyzen contacted Radiadyne with an idea to create a non-latex balloon catheter and jointly develop a product. This is not an unusual way for these collaborations to start. It's a phone call between executives, it's an idea that somebody has, and the parties begin working. The parties here, they signed an NDA and a development and commercialization agreement. And the agreement provided that the jointly developed product will be owned by Radiadyne. So the project was moving along nicely, and Radiadyne started discussions with manufacturers. Then Polyzen filed a patent application on the balloon, naming only Polyzen employees. Not surprisingly, Radiadyne terminated the agreement, and the patent issued shortly thereafter. So Polyzen sued as Radiadyne for patent infringement. The court in this case ultimately looked to the language in the agreement and decided that the patents are jointly owned because the patents included claims directed to the design, and based on case law precedents, the patents were therefore held to be jointly owned. Therefore, the court granted Radiadyne's motion to dismiss the patent infringement claim, ruling that it had shown it was entitled to be recognized under the law as an owner of the patent Polyzen had procured, and of course could not be sued over the patent. So this case is an example of the importance of comprehensive contract terms. Because the development and commercialization agreement was clearly drafted and specified important ownership terms, the court was able to easily conclude that the patent infringement claim should be dismissed. So as a general matter, at a minimum, venture partners should clearly define the ownership of contributed IP, developed IP, and joint IP, which party can register for protection of joint IP, and what happens to joint IP after the JV terminates.
The next case we'll discuss is about a Chinese manufacturer selling counterfeit e-cigarette products after a business venture went south. So the parties here met at a vaporizer convention in Vegas. The China-based manufacturer Wu and the California-based E.D.N.C, who designs and sells and distributes e-cigarette products, agreed that Wu would manufacture the e-cigarette products and E.D.N.C would form a new company called Osmosis. The company would promote, exclusively distribute, and provide warranty service for the products. The parties here disagree on the terms of the agreement. The manufacturer alleged that he was promised a 49% share of the company. The manufacturer claims he was not given his rightful share and claimed that that's why he delayed and stopped shipping the products to Osmosis. Osmosis, the new company, on the other hand, accused the manufacturer of not contributing the promised cash to the company. So, as it often happens in these JV cases, the venture was highly successful, the vaporizer products were popular. But the parties' business relationship soured. The manufacturer began selling counterfeit products bearing Osmosis marks and Osmosis copyrighted designs using multiple alter ego companies. Wu, the manufacturer, claimed that he was granted a license to use the Osmosis design and trademarks and that he was selling the remaining inventory because he was not given his rightful share in Osmosis. Osmosis, on the other hand, claimed that the grant of any such license was only for the manufacturers to supply the products for Osmosis to sell exclusively, and the license was not for the manufacturers to sell the products on its own. So the holding here is that the court agreed with Osmosis and found that Wu did not have an implied license to use Osmosis marks because Osmosis didn't have an opportunity to inspect the products and to exercise quality control over its trademarks because there were counterfeit products floating around in the market that Osmosis couldn't control. So the court granted Osmosis' motion for preliminary injunction. Our practice tip here is to agree on post-termination license rights at the outset of the JV. The agreement should provide for provisions terminating the parties' use of each other's IP upon termination of the JV, if that's what makes sense for the parties' collaboration arrangement.
Okay, and our last case is the Covertech case. This is Covertech the TVM, the 2017 case involving a trademark dispute. So Covertech Fabricating is a company that manufactures protective packaging and reflective insulation and sells numerous products under the umbrella of its lucrative R-Foil brand. So in 1998, Covertech entered into a verbal agreement with TVM Building Products that designated TVM as the exclusive marketer and distributor of R-Foil products in the United States. TVM agreed to refrain from selling competitors' products. The agreement was terminated in 2007 by Covertech when it discovered that TVM had been purchasing comparable products from another manufacturer and passing it off as its own, as Covertech, TVM assured Covertech that its labeling indiscretions were isolated incidents caused by errors in filling its orders, and the companies entered into a new agreement not long after, which was also terminated. Nevertheless, TVM continued to market products using the R-Foil brand name. Covertech ultimately sued TVM, and the trial court ruled for Covertech on its trademark claims, and TVM appealed. In assessing ownership of the mark, the trial court relied on the first use test, a common test, which determines ownership by asking which party was the first to use an unregistered trademark in commerce. However, at appeal, Third Circuit Court of Appeals acknowledged that the first use test is generally considered the appropriate test for unregistered trademarks, but found that the manufacturer-distributor relationship is unique, noting its exclusive and non-competitive nature, and that perhaps a different standard should be used. So the court noted that if the first use test were to be applied, ownership rights would go to the distributor in many cases simply because the distributor made the initial sale of goods bearing the mark to the public. Thus, the court said a different test is necessary when ownership isn't otherwise agreed to by the parties. On appeal, the court held that the so-called McCarthy test should be applied. Under that test, the manufacturer is the presumptive trademark owner. However, the distributor can rebut that presumption using a balancing test that considers the following 6 factors. 1, which party invented or created the mark. 2, which party first affixed the mark to goods sold. 3, which party's name appeared on packaging and promotional materials in conjunction with the mark. 4, which party exercised control over the nature and quality of goods on which the mark appeared. Which party customers look to as standing behind the goods. For example, the party that received complaints about defects or made appropriate replacements or refunds. And which party paid for advertising and promotion of the trademark product. So this test allows for a more thorough individualized analysis of each case that accounts for the unique attributes of the manufacturer-distributor relationship. So applying the test to the Covertech-TVM relationship, the court found that the 6 factors in the McCarthy test weighed in favor of Covertech. This was a bit of trademark detail. There was a bit of trademark detail in this case, but the broader point here is that whenever possible, venture partners should try to address IP issues in the agreement rather than leaving the decision to a court. Because as we saw here, you never know when a court will decide to apply a brand new test. So I'll hand it over to Joy now for some of our key takeaways.
To wrap up, when entering into JVs or collaborative business relationships, be aware of the status of your IP and what rights you have with respect to them. IP ownership, as Michelle and I repeatedly said, is one of the most important considerations when you enter into a JV, and it should be addressed in the JV agreement itself at the time of the formation. Second, share your contributed IP with JV partners carefully. The most obvious danger here is that you might open up too much of your core technology for licensing, and in doing so, undermining your ability to enforce your IP rights when needed. Third, key takeaway is to ensure that the agreement is explicit about what constitutes contributed IP and jointly developed or jointly owned IP. You may want to avoid joint ownership of the developed IP, as Michelle mentioned earlier, and instead consider assigning or licensing contributed or joint IP to JV partners. And lastly, provide for termination of the JV, and obligations of potential future enforcement actions. It's important to plan in advance for possible dissolution of the JV so that ownership and rights to use the JV's IP assets are appropriately distributed among the former JV partners.
Okay, thanks, Joy. It looks like we have a couple of questions in our Q&A. So one has to do with where would the joint development of an algorithm set with regards to IP ownership. I think the question there is really whether that would be covered by copyright or trade secret is a specific question. And the answer there is that both copyright or trade secret could and likely would be used. In very limited circumstances, algorithms can also be protected by patent. That would be an entirely different CLE, but we're happy to discuss that further if you'd like to follow up to the individual who asked that question. There's also a question as to the rights of joint owners in the UK. This is a patent-specific question regarding UK patent law. And I think it probably makes no sense for us to follow up with the individual asking that question separately, as we would confer with our UK colleagues for that. And I'm going to hold off on a couple of the others just to make sure we clear some of our administrative items, and we'll come back to any remaining questions. As a reminder, if we don't get to your question during the program, we will make every attempt to follow up with you after the program. And lastly, as we're just running out of time, we'd like to take this opportunity to highlight an upcoming webinar for those who are interested. On Tuesday, November 5th, we're hosting a webinar on contracting for digital platform relationships. So please be on the lookout for an invitation, which will be sent in the coming weeks. Let me just double check for any other questions. I think there's a question that is asking for a table on the rules on the default rights. And yes, we can certainly follow up with that and make that more clear in the slides. Thanks for that question. I think we would need a follow-up on the last question that was submitted as well, just to get some clarification. So we'll be sure to be in touch with all of you who've submitted questions. We really appreciate your questions and your time. That wraps up today's program. On behalf of Mayor Brown and my colleagues, thank you for your time. I hope you found this program useful. Some final housekeeping items for today's participants. A recording and link to the materials from this program will be distributed by email in the next day or two. For those applying for CLE credit, please note that certificates of attendance will be distributed within 30 days of the program date. To submit topic ideas or receive invitations to future programs, please email us at techtransactions@mayorbrown.com. Thank you for participating. This concludes our webinar.